right? Let's say you're a board, and let's say dues were historically $400 a month, right?
Sure.
High, pretty expensive. And the board gets on and says, you know what? We don't want to do $400 a month. We're going to go down to $100 a month. Okay.
And the neighborhood rejoices.
and at first, everyone's very happy. They're like, wow, it's only $100 a month. That's so great. But all of a sudden, the pool falls into a state of disrepair. The common area starts to fall into a state of disrepair. Why? Because they don't have the money to pay for it. So in a way, the financial negligence lends itself to, failure to maintain common areas, which becomes a violation of the CC&Rs, which you see how it snowballs very quickly.
100%.
I'm Luke Carlson, and for almost 2 decades, my law firm, Ellis Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, Luke Carlson. Welcome back to Bad HOA. With us today, Marty. Welcome back.
Hey, good afternoon.
Good afternoon. Good to see you. It's been a little bit of time since our last episode.
Week and a half.
Week and a half, but it seems like a lot, right?
Yeah.
So, we're back into the revisited space.
Yes.
And I'm excited about today because this one always comes up. It's such a consistent theme with bad HOAs, and that's negligence.
Well, yeah. Tell them a little bit about the revisited series, or do you want me to?
Why don't we both? We'll collaborate on this. You take the lead, or I'll jump in.
All right.
Yeah.
So, we've been doing this podcast for over 2 years, which is mind-blowing.
Yeah.
So in those 2 years, we started off going through all these dispute types, but since then we have developed different strategies and frameworks of which to kind of put these things in, right?
Well, there's been an evolution, and the evolution is really a byproduct of, getting into our subreddit, seeing what, disgruntled homeowners are saying, and really start saying, okay, what frameworks can we start to use, build out for these homeowners when they're really approaching these bad HOAs?
I actually really like that because truthfully, our subreddit has become a really great feedback loop for us. I mean, so many people, before we had comments on our videos and we try to respond to every comment and things along those lines, but the discussion really happens there.
Right.
That's where we can go kind of long form and have a discussion. And so much of this, these guides and things have come from those discussions, which is great. That hub has been extremely popular and helpful to us to craft these new templates. So, which I think is super helpful.
Well, yeah, it gives us real life feedback. It's like, okay, this seems to be a problem. What can we use? What can we draw from our experience to bring to the market, to bring to these homeowners that's actually going to help them? And so with the Revisited series, we're infusing these frameworks into the episodes.
Exactly. Fast forward to a year and a half or more later, and those original episodes were great, but at the same time, we have so much more to offer to them now. That's what the Revisited series is about, is just going through this under a new lens and provide new information that the user on the other end might not.
They're supercharged episodes. And negligence is a big one. This one you see all the time. When you have a bad HOA, this is almost just the second thing you're going to say when it comes to a bad HOA. They were negligent.
Yep. All right. Let's jump in to the framing. You want me to take it here?
Yeah. Yep.
Okay. So, negligence consists of 4 elements. Okay. Duty, breach, causation, and damages. Okay. Can I walk through each one?
Yeah, do it.
All right. Duty, the HOA's obligation to maintain, repair, manage the common areas, and act on known conditions sourced from the CC&Rs, bylaws, and state statute.
Mm-hmm.
Okay.
So, the question is often, why do HOAs have a duty? What's this whole duty? I'm on the board, I'm a volunteer. The answer to that question is very simple. It's because you are managing other people's money, other people's property. So you have an obligation or a duty to, meet the standard of care. There's a certain level, right?
Is duty and fiduciary one and the same?
They're very similar. A fiduciary duty is a heightened duty.
Okay.
So if we're talking about a reasonable or your typical standard of care, right? What is reasonable? What would the reasonable person do?
Yes.
When we talk about fiduciary, that's a heightened standard.
Yeah.
Okay, so in California, that's built into your role as a board member. You have a heightened standard. You have a heightened obligation to care for property that really isn't yours.
The standard is higher than having not have it.
Correct.
Okay.
Yes. So it goes beyond that.
Yeah.
Reasonable standard of care.
Okay, cool. Thanks for the clarification. Okay, breach. Failing to do what a reasonable association would do, ignoring a known hazard, deferring maintenance, hiring a bad vendor, and or not supervising.
Yeah, so the breach is falling below the standard of care, right?
Okay. Yep.
And so, that's sort of subjective in some ways, but if you really look at it, what would a judge or jury say was reasonable or unreasonable, right? So if you're making a decision, if you're a board, and let's say you want to start cutting all the trees in the common area because, you think that they're all diseased, right? Mm-hmm. And you execute on that. And then, you get pushed into a corner, or you get asked, hey, why did you do this? They're like, well, they look diseased. Well, what did you use to back up that position? Did you have an expert? What did you rely upon? And if the answer
leaves were falling.
Yeah. I just I got a gut feeling that there was a problem with these trees. So I cut all the trees, right? That likely will fall below the standard of care because that's unreasonable.
Yeah.
Versus, no, I had an arborist come out, they looked at the trees, and here's the disease that's impacting all of them.
Yeah, or we'd cut down the first one, it showed rotting, and
Correct.
It likely spread, and we tried to do it slowly, et cetera, et cetera. There was method to the madness.
Correct,
if you will.
absolutely. And so again, you got that sort of reasonable standard of care, then you got that heightened fiduciary. So if this was, let's say a lawsuit, you'd likely allege in the cause of action negligence, but then also breach of fiduciary. So it'd be likely two causes of action.
Interesting. Okay. Causation. The breach actually caused the harm. The leak wasn't fixed, caused the mold.
Oh yeah, that it makes logical sense when we're looking at a breach. It has to tether to the actual damage.
Sure.
Right. HOA knew that there was a massive hole in the roof. They didn't fix it. They were on notice. And what happens? Water intrusion event occurs, floods a condo. There's causation, right? It links.
Right.
Right. Because the water was able to come through the hole and destroy the unit.
Right. Which leads us perfectly to the fourth, which is damages.
Right.
So real harm, property damage, personal injury, or loss of use.
Correct. And again, we're going to economic damage. What can we actually show? Is it loss of use? Is it the cost of repair? Is it both? Did you have to leave the property because of the damage? I mean, there's lots of ways to look at damages. But typically what you're looking at is economics.
Are damages sometimes hard to determine? Well, like some of these, so there's things like nuisance, for instance, right? Where there is causation, there is issues there, but there's not an economic factor involved. The noise is just loud.
Well, not necessarily. I mean, in the legal world, we're very fortunate to have a lot of experts.
Sure.
Expert can come in and say, you know what, you lost half the use of this property because of the noise, the nuisance. You didn't get full value of it. Mm-hmm. A very simplistic way of looking at it is, let's say you rented out your home, right? Okay. Let's say it's $5,000 a month. We're in Orange County, so it's expensive, $5,000 a month. But with constant noise coming in, bombardment of these nuisances, whether it's noise, smells, whatever the case might be, it may very well lower the value of the property or the rental. It's just a way to kind of start to conceptualize it from an economic perspective.
So you could do the same basic equation with the pool. Not if the pool is not there, then what is the rental value
and that's one way. And I'm not saying that's the end all be all.
Sure,
but that's a very simplistic way to start thinking of these concepts.
Yeah, that's interesting.
What is the loss of use? Well, do you have full use of the property? No. Why? Because there's some sort of nuisance. There's noise. There's smell. There's something.
That's interesting. Okay. Well, we can get back on the tracks then, and then move on to the key distinction here: negligence versus breach of fiduciary duty versus failure to enforce. They overlap constantly. And then negligence is about careless failure to act. Fiduciary breach is about self-dealing and bad faith. Did we say fiduciary? Negligence and favoritism. So. A single fact pattern often supports more than one.
Well, yeah, when you look at these, it could be just straight negligence. They're falling below the standard of care. It could be, they fell well below their fiduciary obligations.
Yeah.
You can even get into this concept of gross negligence. They went beyond just regular negligence. That's sort of getting into willful misconduct.
Oh, yeah.
Right. They thought that they were going to take all of the association's money and, they invested in some Ponzi scheme. They wanted to make a quick buck or something. It was reckless. It was so beyond the pale.
Yeah.
Now you're sort of into this gross negligence. And that might actually expose someone to personal liability. That's a whole different topic.
Mm-hmm.
But there's different sort of categories even within negligence. And when we talk about negligence, you could spend 10 hours or more on the subject.
We promise the person on the other end will not be 10 hours.
But it won't be 10 hours. Yeah. I think it's safe to say that there's different variations of negligence, different degrees of negligence.
Sure.
And when we look at any dispute, it might not only be negligence, but it could also be a breach of fiduciary, et cetera.
So there's multiple layers to that.
Yes.
Okay. So who's the defendant, the association, the entity, and how liability flows to and through the board, and the business judgment rule as the board's favorite shield. We made a reasonable decision, in quotes.
Well, business judgment is it's something that boards often use as a defense.
Is that like the blanket statement that
course.
most everyone uses as a defense?
Right. It's a business judgment. We're protected. And why do we have the business judgment rule is because courts don't want to micromanage board decisions.
Sure.
But how do you attack a board decision? Well, you look at the logic that supported it or the lack of evidence, right? Was there a paper trail? Go back to the tree example that I used. Okay.
Yeah.
You have two scenarios. One, the board president looked at the trees and says, you know what? They're diseased. I'm going to have them all chopped down. What backed that decision? Business judgment most likely will not protect that decision. Why? Because, if you press the board president on this, it was a gut decision or, it's just my observation as a non-expert versus, hey, I brought in an expert. Here's the paper trail. Here's what led up to this decision. We had community involvement. The more of that you have, the more protected the decision's going to be. And when we're dealing with bad HOAs, what you commonly see is none of that. The community was not notified, right? It was some rogue board member or a rogue board that decided to do something.
Yeah.
And often there's some self-interest there. There might be spite. There might be a lot of things going on.
Right.
But at the end of the day, when you really pierce into it, you find, hey, there was no expert that was involved, that was brought in. There was no discussion with the community. This was a decision that was made behind closed doors. That becomes very problematic. But that's what we're talking about when we're talking about bad HOAs.
Sure. Yeah.
So that's how the business judgment rule becomes irrelevant when they don't have sort of these logical steps that led up to that decision.
Sure. But ultimately the business judgment rule is very subjective and will rely on a judge or jury to determine whether or not.
It can be until you start drilling in.
Sure.
And if you can't show, hey, there was actual paper trail, there was real thought, there was sort of a reliance upon an expert or a series of experts, that business judgment rule becomes, you erode that defense pretty quickly.
Okay, let's jump into some of the fact patterns here.
Yeah.
So I've got several here. All right, buckle up. Here we go. The known hazard is ignored. The broken stair, the dark stairwell, the broken pool gate, cracked walkway, repeated written complaints with no action. It's the cleanest negligent fact pattern. And then there's personal injury exposure.
Yeah.
there.
So, you might even get into, again, gross negligence. If the board was constantly notified of a dangerous condition and they elected to ignore it repeatedly, that goes that's what I'm talking about when I say beyond the pale. That would likely be more of a gross negligence, and that would come under additional scrutiny.
Yeah. The interesting one, which was number 2, that is just sometimes you get in this gray area is deferred maintenance, right? That leads to property damage. So a common area pipe, roof, or drainage the HOA is responsible for fails and then damages the units. That's an interesting one because I could see the reason to defer maintenance to some degree. I feel like there could be a rationale there that is logical and acceptable versus, just keep kicking the can
what
down the road.
With deferred maintenance, it's often a byproduct of financial mismanagement.
They don't have the money to do it.
Well, they don't budget correctly. So sometimes boards will actually, they'll be elected and they're like, they're very proud of the fact that they've never raised dues or they've never taken an assessment, right? But at the end of the day, that has really bad consequences on the community. So arguably that becomes almost financial mismanagement or financial negligence, right? Let's say you're a board and let's say dues were historically $400 a month, right?
Sure.
High, pretty expensive. And the board gets on and says, you know what? We don't want to do $400 a month. We're going to go down to $100 a month. Okay.
And the neighborhood rejoices.
and at first everyone's very happy. They're like, wow, it's only $100 a month. That's so great. But all of a sudden the pool falls into a state of disrepair. The common area starts to fall into a state of disrepair. Why? Because they don't have the money to pay for it. So in a way, the financial negligence lends itself to, failure to maintain common areas, which becomes a violation of the CC&Rs, which you see how it snowballs very quickly.
100%. And this goes back to like experts and things like, why don't you have where's your CPA?
Right.
Where's the person that's handling finances?
Right. And, it's not a very popular thing, but, incremental increases of dues often is a very positive thing for the community is if they're being financially responsible.
Well, I mean, and
I'm not saying something because what you're doing is if you're not doing some sort of increase, I'm not saying something drastic or obnoxious. What you're going to end up with is an emergency assessment. It's a ticking time bomb,
which is much worse than the increment.
Absolutely.
I mean, just in inflation alone, it seems like those dues have to come up at some point just to keep up with inflation.
Yeah. Now, if you say, hey, we haven't changed our dues since 1992. Okay, well, I would imagine that if we looked at your books, you're in a state of financial disrepair.
Or they literally do nothing.
Correct. Yeah.
There's nothing to maintain.
Or the common areas.
There is no common. Yeah.
Yeah, exactly. So.
Okay. Negligent repair. That's interesting. The contractor problem. This is interesting because ultimately the board hires the roofer.
Right.
And the roofer does a poor job. Does that fall back on the HOA? Does that fall back on the board?
Yeah. So this is a great question and it comes up in real life and that's why I like it. Yeah. So when the board hires a third party, a vendor, a roofer.
Yeah.
And the roofer is negligent. Okay. They failed to fix the hole in the roof.
Yeah.
Okay. That negligence is going to flow back to the association under an agency theory. Okay. Because at the end of the day, the roofer is the agent for the association. The association hired the roofer.
Right.
So look at it as the arm. Very similar to a management company.
Sure.
Right. So when the management company drops the ball, fails to maintain common areas, fails to properly, do the accounting for your dues. I mean, all of these things, right? That flows back to the association. And the association cannot hide behind, well, that was the roofer, not us.
Yeah.
Well, you hired the roofer. So that would expose potentially the association to liability under a negligence theory vis-a-vis the contractor.
Right.
Now, realize the association may then have claims against the contractor.
Sure. That's what I was going to get at next.
Okay.
So let's assume they do these things in the right steps. And I'm not sure. You can educate me and say, oh, the bylaws or the CC&Rs will say that they have to get 3 competing bids.
Okay.
I'm not sure.
Fairly common.
Okay.
Right.
They get 3 competing bids. They're all licensed. They do their due diligence. Everything looks good. They get a decent roofer on paper. Roofer comes in, does a poor job, causes damages. The first thing that I would assume is that the board is on notice. Hey, my roof is leaking.
Right.
Now, the board would then, I would assume, go directly. We would keep the communication pipeline open between the homeowner and say, okay, we're going to try to solve this. We contacted the roofer and we're working our way through this thing.
Yeah.
It's half of the issue because that doesn't seem like that's a board problem. That seems like they did their due diligence. They picked someone that's reputable. An expert can even corroborate and say, yes, I think they did their due diligence. At the end of the day, though, still the board's issue.
It still falls on the board. Now, we don't advise boards. we're homeowner side.
Of course.
But a board in that scenario, if a roofer came in, did a horrible job, I would argue that the board now needs to find another roofer to get out there to fix the problem ASAP.
Sure.
The problem still exists.
Right.
And just because your first rodeo or your first repair attempt failed doesn't absolve you from responsibility.
Sure.
So there's still this proactive requirement that they have to find someone else. They still have to fix the hole in the roof.
Do you ever see where an HOA is in a legal tilt with some sort of a contractor, and then they're moving forward and trying to work this thing out. Meanwhile, a homeowner says, "That's enough time. I'm coming in here and I'm going to go after the board." Does that happen? As well.
But I think it all goes back to what's reasonable. It's a reasonableness standard. And so if you're looking at, hey, if the board keeps saying, hey, we're working on it, but it's 9 months down the road.
No longer reasonable. Is
it reasonable? I mean, that seems like a very long time to fix something as urgent as a hole in the roof.
Sure.
Versus, hey, it's been 9 days. We've already have someone lined up. They're coming out on day 11 and it's going to get patched.
Understood.
Okay. Are they being proactive? And again, if these things do, get to the stage of a lawsuit, you're looking at the paper trail.
Yeah.
How proactive was the board? What were the communications like? They should be, hey, we need to have a meeting. We need to, fix this. We need to source this. This is urgent. You see that sort of urgency within the board.
Yeah.
Versus nothing in a lackadaisical approach because it's, what is it? Not my sink, not my dishes, even though it is. It's like, this isn't affecting me. I'm the board. I don't care about it.
Sure.
We're going to drag our feet. We're going to stonewall this person for whatever reason, right?
Yeah.
So again, it's what was reasonable in the circumstances.
Yeah. Okay. So number 4 would be negligent hiring and supervision of vendors and management. I think we just went over that. Picking an unlicensed, uninsured contractor, ignoring the red flags with no oversight. I mean, I think that speaks, that's really well tied to number 3.
Falling below the standard of care. What would a reasonable person do? Well, a reasonable board member probably wouldn't hire an unlicensed contractor.
Right.
Right.
Unless it's a little bit of self-dealing.
Unless it's cousin Saul and you're getting kickbacks.
Yeah.
That becomes self-dealing. That becomes a whole different thing.
Right. Okay. Foreseeable harm or inadequate security. Broken gates, no lighting, known criminal activity the board ignores, where premise negligence meets foreseeability. That's interesting.
You see this a lot where there is... Well, first, the question is, did they guarantee some sort of security in the first place? And sometimes they don't.
Right. Does that guarantee of some security, meaning like a gate or something? Often it's in the governing documents.
Right. But let's say they go so far to put up security measures. There's some sort of obligation in the governing documents for some sort of security, and they just fail to provide it. Or they know that, hey, our back gate's broken. Our front gate's broken. Our security cameras are all kaput.
Yeah.
Okay, that becomes problematic. I mean, not only is that negligence, arguably, but that also could be a violation of the governing documents themselves.
Sure. Yep. Makes sense. Okay. The gray zone.
Okay.
I think it's worth talking about the gray zone.
Yep, lawyers like that.
Or ordinary accidents with no breach, a freak event, the hidden defect no one could have known about. Yeah, I think that there's a gray area here, right?
Well, it goes to, again, we go back to this reasonableness standard.
Right.
And if it was unforeseeable, if no one could have predicted it, if the board is taking they have an expert and they're, complying and they have paper trails and there's a lot of thought and logic and something just comes out of nowhere and occurs, then maybe it's not negligence.
From your experience, do a lot of HOAs have like maintenance schedules and things like kind of baked in?
Well, the good ones, yeah.
The good ones do.
Okay, so let's talk about roofs because as we were saying before the show, roofs come up all the time.
Yeah, there's a lot to...
Pipes do too. Yeah. Pipes between common areas come up a bit.
Yeah.
Green belts come up quite a bit.
Drainage.
Drainage comes up a lot. All of this stuff, right? But really good associations, they have experts come in and they say, hey, if you're going to, if you're going to protect the roof, you need to inspect it once a year, twice a year, whatever the case might be. And that puts it on a schedule. And now the board can say, yeah, we talked to a licensed roofer and they said, twice a year is sufficient. Or the green belt, the drainage should be checked maybe every quarter. whatever the case might be. But that starts to set these inspection sort of frameworks within a community. And often if you read the CC&Rs, the governing documents, it's not only a duty to maintain, but it's also to repair. So it's maintain and repair. To maintain and repair often also means to inspect, to be sort of aware of the situation, right? Frequently go out. But again, you defer to an expert. It's not just because the board member says, hey, I've never done anything with roofs before, but I think we need to be up there once every 10 years. That should be enough. Well, again, going back to the business judgment rule, you're probably not going to be protected by the business judgment rule in that scenario.
Yeah.
However, you get a licensed roofer who says, you know what, because you're in this, location, we recommend every single quarter. Someone goes up there and just double checks.
Yeah.
Okay. Well, the board may very well be protected by the business judgment rule at that point.
Yep. Makes perfect sense. Okay. So in this series, there's I guess 3 reasonable tests here, right? Number 1, damages versus quality of life, right? Is there real measurable harm? Number 2, reasonableness. What would a reasonable association have done? Was the danger foreseeable, right? I guess those are 2 kind of things wrapped into one. And notice, did the HOA know or should it have known? I mean, this is really the linchpin of everything from there.
Yeah, notice is a big one. But again, that notice is often sort of self-imposed or self-driven through inspection.
Right.
Just because, if a hole happens in a roof and they never inspect a roof and they can't say, well, I was never notified. Well, yeah, but you had an obligation to inspect.
Sure.
Right.
Yep.
It's not the homeowners who need to constantly be notifying the board of these situations.
Right.
So yeah, I think that's a good test, if you will.
Well, let's look at the other side of the coin when it's not HOA negligence to give a little bit of a contrast here.
That's good.
All right. The damage inside your own unit, your maintenance, your responsibility. That's not the HOA's duty. I think this goes back to condos that we talk about a lot. We're going back to the pipes in the roof. Roof leaks into your unit.
Right.
That's really the cause was the common area.
Right. Where is the source of the damage?
Right.
Is it common area or is it within your own unit?
Right. We also talk a little bit before and lots about pipes, particularly inside a condo. If the condo's pipes on the inside are leaking and it's known inside is causing a problem to yours, it's likely going to be
inside the walls versus going into your unit.
Right. That connection for that the trap underneath your sink. Okay. Probably your problem.
Probably. Yeah.
Yeah.
Or your bathtub.
Yeah.
Your bathtub gets clogged and it floods the unit.
Yeah.
Well, the association doesn't have a duty to maintain your, bathtub.
Right. Right.
Or inspect for that matter.
Okay. The second would be a pure accident. No notice, no breach. I mean, we live in the real world. Like a pure accidents do happen.
That goes to the unforeseeability of things.
Right. Okay. It's actually a neighbor's negligence, not the association's. That's an interesting one too.
Yeah. Well, that is very frequent in condos where you have a flood in an upstairs unit impact the downstairs unit.
Yeah.
So that would be likely a neighbor versus neighbor situation.
Or perhaps you live on a slope and you live on one person lives property and they're not maintaining their slope. Right. And the drainage then gets clogged.
Drainage is a big one.
Yeah, and then floods the neighbor down the hill from
you. If it's not in the common area and it's on someone's actual property, again, the association has no obligation to maintain that part of the community.
Yeah.
So
this is interesting. The insurance first situation. Sometimes the answer is tendering to the HOA's policy or your own, not litigation. That's interesting.
It's interesting, but at the end of the day, so you take a flooding situation where let's say it's a common area and there's a water intrusion event and your unit gets wiped out.
Yeah.
Often the knee jerk is to go to your insurance, the homeowner insurance.
Yeah.
Homeowner insurance says, well, that was sourced from a common area because maybe there's an expert report. Mm-hmm. That's not on us. So then what likely happens is you go to your association. A good association may very well tender. Okay, because it's a negligence claim. It's in errors and omissions, right? So that's an E&O policy, right? So the the industry of association, or the association industry, was set up understanding that there could be mistakes, that there's likely going to be mistakes. Why? Because these people are volunteers. So there's a whole insurance industry around associations. Sure. So when you have clear negligence and the association is put on notice of that negligence, like I said, a good association tenders to their carrier. Okay. Now, bad HOAs, though, what I've seen, they don't. They say, well, not our problem.
Kick the can.
Yeah. We're not going to do anything.
But then it's this horrible back and forth between
It can be. And we'll get into this. What do you do when it's a big back and forth? But when a legal demand comes in, right? A demand from a lawyer saying, hey, this is negligence. This is a breach of fiduciary. What becomes very interesting is in that insurance policy, there is a requirement that the board notify the carrier in the event of a threat of legal action or illegal action. Oh. So the demand letter from the lawyer alleging negligence may very well trigger the association's obligation to report to their carrier.
Interesting.
Yes. And so that's why, some of these demand letters, the demand for ADR, can be very impactful.
Interesting.
Because it forces the hand of the association to get the carrier involved.
Assuming they follow the
Assuming so. But it's danger. I mean, it's very dangerous. Well, this would actually be, it might be in the governing documents, but it's likely in the actual policy.
Oh, sure.
Now, what gets interesting is, let's say they don't, and then, what do you do then? There are ways to sort of work around that, but it becomes very interesting. But you can sometimes just force the hand of the association to notify the carrier by way of a legal threat.
Interesting. Can a homeowner get a hold of an insurance policy like that? Is the insurance policy part of documents that they can request?
It depends. I mean, bad HOAs, it's hard to get any documents, including the governing documents.
Yeah, sure.
Better associations, very easy to get a hold of an insurance policy.
And a lawyer's favorite phrase, depends. All right, so the strike method, for those of you who do not know what the strike method is, it's our framework on trying to solve these disputes on your own. Kind of gives you a 1, 2, 3-step process on just about anything. So we've adapted the strike. It's an acronym. We've adapted it to this particular dispute type. So if you don't mind, let's go through
please.
it. Okay.
I love it.
S stands for stay calm. Crisp, factual, concise communications. Assume a judge, mediator, opposing counsel reads everything. Strip the emotion, write it, don't address it, run it all through AI, send it in the morning. The 3 a.m. Venom email becomes their evidence.
Yeah, we've said this before. Your very angry email, which is 100% justified. It is. It's one of those things where you read it and you're like, yeah, I totally get why you wrote this.
Yeah.
But it does not help you at all.
Yep.
That's Exhibit 1 from the association.
Yep. Yeah. I mean, I think I've said this so many times, but it bears repeating that one of my favorite tools or little tips here is just assume a judge or opposing counsel is going to read everything.
100%.
I feel like that is probably one of the best little tips in here because it just reframes everything at that point. And then to the extent, I mean, if they do, you are trying to put a contrast between you being the reasonable party and them being not so reasonable.
Correct.
You're always the reasonable one in their show. They're the venom spewers.
Yes.
Shows they're unreasonable. It's going to bode well for you.
Yeah, the more unhinged they are, that's probably going to be a good thing for you down the road.
Yeah.
Don't respond to their lunacy with lunacy.
Yeah.
The more cool, calm, collected, the better.
This is a fight fire with fire is not all in terms of your reaction. It's not helpful. Okay, let's go to T and strike is track everything. Put them on notice. Verbal complaints don't count. Formal written notice of what happened. They can't say they didn't know. I mean, this is one that I really love too. This is, I think, on the back of the other one is making sure you memorialize everything in writing. If you went to the potluck and say, hey, I have a leak in my my unit, and you told the board president, and you guys had a discussion about it. After you've consumed the casserole, go home, write an email, say, this is based on our discussion. These are the points, X, Y, and Z. And my favorite thing that you added to that was if this is not, if my understanding is different than yours, then please reply with yours.
Please respond in writing.
Please respond.
Yeah,
in
if anything is not accurate, if you disagree with anything, please respond in writing.
Yes, I love that one, because that also means if they don't respond, they're saying they're implying that
it's
everything's factual.
Yeah, it's not a slam dunk, but it's very strong evidence.
Right.
You know, you go to the board president and you say, hey, just wonderful seeing you tonight. Very nice potluck. Love the casserole. Thank you so much for hearing my complaint about the leak. It's been ongoing for 2 weeks, as I discussed. If you have any further questions or need anything, please respond to this email.
Yeah.
You can even do it that way. It doesn't always have to be so contentious necessarily, or so drastic or even too legalese if you're trying to sort of keep the peace.
Yeah.
But it has to be in writing, and it has to have something that puts them on an obligation to respond if anything is amiss.
Sure. Yep. Love that. Okay. Record and organize evidence. A timeline of complaints and responses, dated photos, videos of the hazard and the damage, repair estimates, medical records if there's injury, clean file that proves causation and damages, saves attorney time and money. I love that too.
Record and organize everything too is very important, because when you're in a dispute like this, it will seem like time goes very fast. And all of a sudden, where you think you're going to remember everything, it becomes jumbled.
True.
And the
100%.
last thing you want is a jumbled timeline. So you might not remember. It's like, okay, I told the board president at this time, but I think that was after the contractor came out, or was it before?
Yeah.
And all of a sudden, even 2 or 3 weeks becomes very hard to reconstruct.
And that's the type, if you don't have, and we'll get into this a little bit later in this method, that's the type if an attorney from the board comes on, they're going to try to eat you alive on your quote unquote facts.
Right. And the more you can keep with what actually happened, the more evidence, the pictures, the video, just keeping the log. Yeah. Hey, on Tuesday, I saw the board president. I told him this and I sent an email.
There is an economic factor. Should this get to the point where you need to
100%
to get to an attorney, that if you are well organized and can convey this concisely, and but also with the appropriate amount of detail to an attorney, that means that the law firm does not have to go through a dozen legal boxes.
Right.
There's an economic benefit to that, where everything's been the transfer of knowledge has been very efficient. Therefore, less hours are put into the case, and you win on that front.
Yeah. So I think in the tech world, maybe it's called UX, user experience, but it applies to attorneys too.
Yeah.
And so, attorneys are very good at piecing together timelines. Mm-hmm. And if you gave me 10 banker boxes right now, all jumbled, I could put the thing together, and I could tell you what's missing. I could tell you what evidence is missing. We could reconstruct the whole thing, but it's going to take a long time.
Yep.
Versus a very clean, let's say it's a folder or a binder, everything's laid out. It's just so much it's more user friendly for that attorney. They don't have to piece it together, and then they can go through it, and then they can maybe say, oh, you know what, we're actually missing some information here, or what happened here. And then it just becomes that much more seamless of a transfer of information, data transfer.
Yep. Okay. I and strike, invest in knowledge, read the CC&Rs, bylaws, rules to confirm the maintenance and repair duty that the HOA is responsible for, plus any of the governing statutes. And I'll go through the hierarchy again. Remember, it's federal, state, local, CC&Rs, bylaws, and then rules as well. Another pro tip would be, so go through your CC&Rs, go through the appropriate laws. If your CC&Rs are paper, you can scan them and that magical Control F to start looking for specific things in them. And I mean, you can always load it into potentially an AI tool and say, start looking through this and find it. We live in what a world we live in today.
So basically do your homework.
Yeah.
Because it's very powerful. It's powerful, I think, in and of itself to say, hey, this is a violation of the governing documents.
Yes.
It's so much more sophisticated, though, to say you're in violation of provision 7.21. And here's the language.
Great segue to the K, which is keep it precise.
Yes.
So don't write you were negligent. Write the association has a duty to maintain the X provision, 4.1, page 12. It was notified on dates. It has not acted, and the failure has caused blank damage. and then pinpoint duty to notice plus harm. I mean, wow, that is much more powerful than name calling after the plot line.
Well, the show is all about empowerment.
Yeah.
And if you really, empowerment sometimes sounds a little vague too. It's like, oh, we're trying to empower people, but the language is what empowers people.
Yeah.
I mean, if you really look at all of this, I mean, you got to do your homework to find it in the first place.
Right.
But the K is really the execution of that empowerment.
Yeah.
You can say, you guys are a dumpster fire, you're a train wreck, and I'm so mad. And it makes sense as to why you would.
Yeah.
But if we're talking about what gets people's attention, what gets the lawyer's attention, is when you start citing code, when you start citing exactly what the board did wrong with precision, that's going to get the right attention.
Right. I mean, something that says a venom spewing, email that comes in versus might get ignored.
Yeah, you don't want to get written off.
Right. Exactly.
And the board attorney, if you send a bunch of venom, which again, I understand why you do, but if you do, that attorney might say, well, this person is just out of their mind. I'm not going to put much weight into it. Versus the more sophisticated approach. Now the attorney goes, okay, maybe there is something to this. Yeah. That's where you want to be.
It might flag it in a very positive way for you.
Yes.
Okay. The last is E in strike. Escalate only if necessary. Sometimes the best thing is to not just go for scorched earth as the first method, to try to be reasonable. Again, we're going back to the very first thing of staying calm. Be the reasonable party. Try to work this out. Be the reason. Always show that you're the reasonable one. And then only escalate if necessary. Write the written demand letter, a formal notice, and then in California, IDR under Davis Sterling. And we have an entire episode. We've talked about IDR extensively. But just to give a quick sentence on it.
Yeah. So under Davis Sterling, they built in the informal dispute resolution.
Yep.
And they did so because they ultimately wanted homeowners, boards to come together to work things out.
Without
legal intervention, before it really, got out of control.
Right.
And so IDR was a great way where it said, hey, the homeowner has a right to demand IDR, which is really forcing the board to come to the table to discuss these issues.
Yep.
Before really legal intervention was required.
Yep.
And the obligation on the board is they show up in good faith to try to work these out.
Yeah.
Now, I've said this before. You can run this play beautifully. You can demand IDR. You can show up, and you could get hit with an absolute insane board that's just screaming at you and just is acting outlandish. And that could happen. Just because the code, sort of demands that the board shows up in good faith doesn't mean they're going to.
Sure.
So if they do, don't engage. I think that's probably some of the best recommendation.
Like
right?
you went in good faith. They clearly didn't. You can end it, and then without getting...
you don't have to subject yourself to additional punishment,
right?
If you don't have to.
Yeah.
So you tried, you checked the box, and now down the road, if it goes to mediation or if it goes all the way to trial, you can show, hey, I tried initially to resolve this. I sat down with you guys. I tried to work this out, and instead, the tyrant board member screamed and yelled the whole time, saying it wasn't, their fault, even though it was 100% their fault.
Yeah. Yep.
They tried to intimidate, right?
Yep. All right. This is a fun one. Let's go through the pitfalls. What wrecks a good negligent case?
Okay.
So
what not to do?
Number one is no notice, no paper trail. The number one case killer. You can't prove what they knew.
Yeah, I like this one because, again, it goes to being proactive in enforcing your rights.
Yeah. So
you have water intrusion and you don't tell anyone for 6 months. Okay, that's going to be on you at some point.
For sure.
There's this, not to get too technical, there's this theory of latches where if you wait too long, if you're not proactive and because of your delay, it causes more harm, that's going to count against you.
Yeah.
So be proactive, put the board on notice, document. That is essential.
Yep. Number two, self-help repairs that muddy causation. Fixing or altering the hazard yourself before it's documented or an expert reviews it can destroy the evidence and shift blame to you. That is a spicy one.
Yeah, and this one is interesting because, if it's a common area, you don't have a legal right to repair.
Right.
Now, there's certain exceptions, but generally speaking, don't tamper with a common area. Because at the end of the day, that might blow back on you.
Right.
and they might use it. Again, I would always assume the worst. And we live in the world of bad HOA. So assume the worst from your HOA, and maybe they prove you wrong. Maybe they're actually good.
If you're listening to this, there's a good chance your HOA isn't good HOA.
So assume they're going to weaponize what you do.
Yeah.
And let's say you go out, you try to fix something. All of a sudden, they're making allegations that you caused it in the first place.
Yeah, brutal.
Don't even get in that situation.
Yep.
Document, send them, put them on notice, give them the urgency, tell them what it's doing, how it's damaging. But don't think that you going out and being proactive and fixing a common area is going to help you. Even though if you're doing it altruistically, and I understand why you would, it's not going to help you legally.
Yeah. Yeah. I like that. Okay. Secret recording.
Don't do it.
Yeah. We're going to speak California. California is an all party consent state. Don't turn yourself into the violator. If you do, number one, it's not legal to record, and they're just going to throw it out as evidence.
It doesn't help. Again, I'm not a criminal lawyer.
Yeah.
Right? But you are violating certain penal codes when you record secretly. Just don't do it.
Yeah. I think we all have the recording thing on our phones. So easy just to pull it out as you're having these conversations.
Say, hey, and you can say, hey, I want to make sure that we are all on the same page. I'm going to record this just to make sure there's no ambiguity.
Yeah.
Get consent.
Yeah. Yep. Okay. Number 4, retaliation/withholding dues. Feels justified, hands the HOA ammunition, and flips you into the defendant.
Yep. So this is common, and I understand, again, why, but here it is. You're failing to do certain things. You're failing to maintain common area. You've caused all this horrible situations for me. I'm living outside of the property. I'm not going to pay my dues.
Yeah, doesn't that feel like justice, like in a certain way?
It does, and I get
you're
why.
You feel like you're holding some sort of cards.
You're not upholding your end of the bargain. Why should I be paying my end of the bargain?
It feels good.
But it is a trap, and you never win at the end of the day, because ultimately what happens is they're going to flip that into a breach of contract or a breach of violation of the CC&Rs. They start an offense against you, saying, hey, you owe the money, or they weaponize it and they try to do a lien on your property. I mean, there's so many things they can do with that.
Yes.
Stay above board. Pay under protest. That's fine. But just know that withholding is just going to put you in a bad legal position. If you're wearing the white hat, if you've done nothing wrong, don't step into a position where they can flank you.
Yep. I love that one. Okay. Waiting too long. We just talked about this, but letting damage compound, that roof that was leaking turn into mold, a structural issue, and that you might have blown past the statutes of limitations.
Well, it's one of those things where I said before, you got to be proactive with your rights.
Yep.
So.
Yep. All right. Let's round towards home here.
Okay.
Signs to bring on a lawyer. We've gone through these before, but let's do it again. It definitely justifies it here. Okay. Number 1, the HOA stonewalls or denies the duty despite documented notice. I think that's a good one. Have someone review it.
Yeah, there's an issue where if you're following this playbook, if you're putting them on notice, if you're following up and they are either not responding or they are simply saying, hey, this isn't our problem, at that point you may want to escalate. You may have to break through that stone wall.
Yeah. Yep. I like that. Ongoing or escalating damage. We talked a little bit about water intrusion and mold, but I mean, if water's not dealt with, it can fester and cause a real issue.
Yeah. So it's kind of similar to dragging their feet, but also it's sort of case by case. If your unit is constantly being bombarded with water and it is flooding and they are just taking days, weeks, get a lawyer.
Yeah.
Or at least talk to a lawyer.
Right.
Because they may be able to speed up the process.
Right.
Because you also have to look at it, you have the board, but the board should have some sort of counsel, hopefully legal guidance of some sort. Sometimes the attorney doesn't know what's going on. The board's attorney doesn't know what's going on.
Yep.
When you get a lawyer to fire off a letter or let's say a demand for ADR or alternative dispute resolution, that might get it into the right camp.
Yeah. That
might actually bring the adult in.
Yeah.
Of course, there are situations where the association has weaponized the attorney, which is a whole different episode. But at least, start to get some traction on this.
Yeah. Yep. Personal injury. I mean, if you're injured, that might be a good time to call an attorney.
So we're not personal injury lawyers.
No.
But
I think that's worth noting that if there's a slip and fall or something because of a drainage issue caused by the HOA
or a mold issue.
Yeah.
If you find that you have a mold spore in your lung.
Yeah.
Right. I mean, kind of joke about it. It was very serious though.
Right.
I mean, mold can be absolutely devastating. Any sort of injury to the person, talk to a PI lawyer.
Right. Yep. Okay. I love this one so much. It's just so easy that if the HOA shows up with its own attorney, it might be time to call your own. I like this because of what we said earlier, because the attorney is as friendly as they may sound. They may frame it that they're on your side, but at the end of the day, they work for the HOA.
Yeah.
And the HOA is run by the board.
As I say, anything can and will be used against you.
Yep.
Adopt the same psychology when dealing with an HOA attorney.
Yeah. They're potentially going to try to paint you into a corner.
Correct.
So,
correct. Or they might try to weaponize what you say to them.
Right. Just
be very mindful. And if an attorney pops up or you get an email or a correspondence from a lawyer.
Yep.
You may want to talk to a lawyer.
Yep. I think that rounds out nicely.
Yeah.
Yeah. I mean, I think there's a lot of good points on this one for sure.
Well, negligence is a big one.
Yeah, for sure.
And so, by looking at it through sort of that elevated lens, knowing how to tackle it, it's going to put you in such a better position.
Yep.
Instead of being reactive to the situation.
Yep.
So, very good.
I like it. Until next time, huh?
Until next time. So thank you, Marty. And thank you guys for watching. Again, please subscribe, like the video, and check us out on our subreddit, Bad HOA. And we will see you next time.